Hello, I'm Max Wiegard. I'm an environmental, land use, and real estate attorney with Miles in Stockbridge. I've been practicing law for about 20 years, and today I'm going to speak to you about environmental law and how it intersects with real estate transactions, specifically commercial real estate transactions, and give you some thoughts on how to factor and analyze environmental law's effect on real estate transactions during the transaction planning and preparation process. My interest in law started at the University of Virginia, where I served on the University Judiciary Committee and first year Judiciary Committee as an elected judge. Before that, I thought that I wanted to become a physician and practice medicine. And my interest in science commenced when I was a child in Northern Virginia, and then ultimately blossomed when I was a student at Thomas Jefferson High School for Science and Technology. But once I was an elected judge and saw how fun it was to preside over cases and learn the nuances of a student self-governance system, I decided that pursuing the law would be a great opportunity for me, and it has been. In addition to that, I've been very fortunate and blessed to work with a number of mentors, specifically three that I'd like to recognize. One is an attorney named Charlie Williams with Gentry Locke. Charlie and I worked together for many years on environmental projects, and he has been instrumental in encouraging me and inspiring me to pursue environmental law practice and to learn about how I can serve clients and help them as they manage environmental risk. Also Mike Pace, who was a wonderful mentor to me in the areas of land use and zoning law. Mike was a gentleman and an extraordinary lawyer who I miss very much. But he taught me many things about being a practicing lawyer and about how to communicate with people on the many sides of various issues in land use projects. And then Frank Flippen, who taught me many things about real estate transactional projects and how to manage clients' real estate project and transaction from start to finish in a way that serves the client's interests and maximizes their positive outcome. So I would encourage those of you who are commencing a real estate law practice or law practice in general to find some good mentors, but also look for opportunities to do new and different things, to push your boundaries and try things that you may be interested in. That certainly worked out for me very well, as I had an opportunity to work on an environmental law project when I was a young associate at Gentry Locke, and the rest, as they say, is history. My discussion will focus mainly on the portion of a commercial real estate transaction during the diligence process and leading up to closing, and how an environmental attorney and real estate attorneys as well can help identify environmental risk, assess environmental risk, and then develop a plan for managing environmental risk. Joe Romero, who's presenting with me, will focus his presentation more on the process of managing environmental risk while property is owned and operated, and then also when the property is closed and decommissioned or a facility is decommissioned. To talk about environmental risk and how to go about identifying and assessing it, I think we first need to talk about environmental media, because environmental law and policy and regulations in the state and federal level focus on various environmental media and regulating those media directly. Environmental media that are regulated at the state and federal level include water, air, land, and waste. Now, we also need to think very broadly as a real estate practitioner who's planning for a real estate transaction about what the nature and scope of potential liability is that we should be concerned about. That liability includes the potential cost of cleaning up environmental conditions and contamination, potential damages to third parties resulting from a release of a hazardous substance, administrative charges that may be imposed by a state or federal regulator for violations of environmental regulations, and potential increased costs of compliance that a new owner or operator of a facility may incur, or a current owner and operator of a facility may incur after a release of a hazardous substance or after an episode of noncompliance with an environmental regulation. And a final concern that we need to be aware of is the potential limitations on future use of property resulting from an environmental condition that's discovered in the course of preparing for a transaction. We also need to focus on, learn as much as we can about the use of a particular subject property in three phases. One, its past use and historic use. Two, its current use. How is it currently being operated, and what are the current conditions of the property? And then the third element, of course, is the future use. What does our client plan to do with the property, and how may the property be used even after our client finishes its ownership and operation of the property and sells it or leases it to somebody else? Now, as we collect information about these various issues, we also need to think very critically about a number of elements of potential risk that will influence the nature and scope of risk that our client could be inheriting. Again, we've already addressed past and current uses of the property. But we also need to look at things like the potential exposure pathways, based on how we expect the property will be used in the future, and its surrounding uses, how are environmental contaminants or hazardous substances likely to reach or affect other neighboring uses or visitors to the property itself. We also need to look at whether there are any existing use limitations on the future use of the property, such as a restriction on use of groundwater in the future, or a restriction on use or soil disturbance in certain areas of the property based on existing contamination. Are there any regulated environmentally sensitive areas on the property, such as wetlands or similar sensitive resources, such as protected species? Is there evidence of bats or things like even the tiger beetle on the eastern shore that are threatened or endangered species that have to be taken into account when determining how a property may be used in the future? And then also, what operations on the property, specifically if it's an industrial facility or other commercial facility, are regulated operations that we need to take into account when determining how to transition into ownership and operation of the property that is the subject of a transaction. One of the environmental regulatory frameworks that probably influences real estate transactions more than any other is CERCLA, or the Superfund Law. This is a law that was established in the late 70s, early 1980s, to impose or create a regulatory framework for the cleaning up of contaminated sites that didn't have owners or operators who were ready or willing to clean them up on their own. And in doing so, Congress created and the EPA created a framework that establishes a broad scope of liability that's retroactive, it's strict, and it's joint and several, meaning that if a person falls into one of several categories of persons, they are potentially responsible for the cost of cleaning up a property, and not just their proportionate share of that cost, but potentially the whole cost itself. That those categories of persons, potentially responsible persons, include owners, both current and past owners of the property, operators, both current and past operators of the property. So think a lessee who is operating a facility on the property may not own it, but it still is an operator for purposes of potential environmental liability under CERCLA. And then because liability is joint and several, state or federal regulators can look to any potentially responsible party as specifically the one with the deepest pockets as the party that they choose to pursue a cost of cleaning up the facility from. Then that party would have the right to, under CERCLA, to seek contribution from other potentially responsible parties through a contribution action. And there are very few statutory defenses to CERCLA. I mean, when I say very few, things like act of war or act of God would be the only available defenses. There are, however, some safe harbors from potential CERCLA liability, and these are very important to take into account and really plan pre-transaction, both transaction structuring and transaction diligence around. Those safe harbors include the innocent landowner defense, contiguous property owner defense, and the bona fide prospective purchaser defense. Now, for a prospective purchaser of a property, as you may suspect, the most important of those three is the bona fide prospective purchaser safe harbor. This requires that a prospective purchaser of property to be shielded from potential liability under CERCLA meet the regulatorily established all appropriate inquiry standard, which in this day and age requires a prospective purchaser to hire an environmental consultant to perform at least a Phase 1 environmental site assessment of the property following the current ASTM standard for Phase 1 environmental site assessments. The purpose of that site assessment will be to look for potential recognized environmental conditions on the property, and if those are discovered in the course of the review of available information about the historic use of the property and the site visit that's required for a Phase 1 ESA, then the environmental consultant will likely recommend a Phase 2 environmental study, which would involve collection of environmental media, sampling and collection of environmental media, and analysis of that environmental media like soil or groundwater for potential constituents of concern. If those are constituents of concern are discovered, then there may be some regulatory requirements, depending on what's discovered and where, for disclosure to state or federal regulators and possibly even affirmative environmental cleanup of the discovered constituents. Now, a few thoughts about now that we've discovered we've discovered the environmental conditions on the property or collected information about those environmental conditions. Based on with the results of that study and that collected information, the next step is to develop a strategy for mitigating risk by contract. So in crafting a purchase and sale agreement for property or a lease agreement for property, there are a number of different types of provisions where environmental risk can be actively managed. Those include conditions to closing, representations and warranties, indemnity obligations, affirmative obligations to disclose, remediate, and remediate environmental conditions or comply with environmental regulations, as well as financial insurance provisions that require one of the parties to establish a financial mechanism for ensuring that closure regulations or some future environmental obligations are met. Sellers frequently want to purchasers, let's start with purchasers, want to know as much as they can about a property so that they can develop a plan for addressing any existing environmental risk and requiring a seller to bear as much of that responsibility for existing and past conditions as possible. Sellers, on the other hand, their objective is often to limit to the extent possible their risk of potential liability post-closing. So after the transaction closes, they want to be able to walk away, take the proceeds of the sale, and use it as they please. On the other hand, lessors, that is landlords of property, have a somewhat unique interest in the scheme of transactions, because they generally want to prevent themselves from being responsible for any risk or any conditions that are discovered or caused during the term of a lease. They also want to protect themselves and protect the property and the condition of the property for when they take back possession of the property at the end of a lease term. Before we conclude our discussion, I'd like to briefly address a state mechanism for actively managing environmental risk that has been, at least for my clients, a tremendously useful mechanism. That is the Virginia Voluntary Remediation Program. This is a program under which owners and operators of property can enroll the property that is not subject to mandatory remediation requirements under some state or federal statute, and work with the Virginia DEQ to bring the condition of that property to an acceptable level of risk. The steps in that process involve characterization of the nature, scope, and extent of environmental contamination on the site, assessment of the risk posed by that contamination, and then development and then ultimately implementation of a corrective action plan for cleaning up and addressing that risk. Again, it's a risk-based program, meaning that there's not some established standard that is a mandate by the state or federal regulators that has to be met by the property owner. Instead, by using several different tools and a combination of several different tools, property owners are able to have some flexibility in developing a strategy for achieving an acceptable level of risk. Those tools include future use restrictions on the subject property, institutional controls on the subject property, as well as active remediation. Institutional controls or other conditions, things like establishing an impermeable barrier between operators or users of the property and contaminated soil or something like that. But at the end of the voluntary remediation process, owners and operators of a contaminated property will receive a certificate of satisfactory completion of the voluntary remediation project, which they can, from the Virginia DEQ, which they can use to market the property in the future and provide some protection against future cleanup requirements or proceedings, certainly at the state level, but also under a memorandum of understanding with the EPA at the federal level as well. By asking questions, being curious, understanding the detailed nuances of how a prospective client or your client intends to use property, and collecting information about how it's been used in the past and how it will be used in the future, it's really a fun and exciting process to establish a strategy for how to identify, address, or assess and manage environmental risk in the context of a real estate transaction.